Thank you, everybody. Have a seat. Well, Mr. Stockton, I see you have a full complement of everybody that you guys are back on board, right?
Brought plenty of that.
William Brooks, Commonwealth versus William Brooks.
Good morning, Judge.
Mr. Hunley. Commonwealth versus William Brooks. Are you William Brooks?
Yes, sir.
Good morning.
Good morning.
Were you born in 1983?
Yes, sir.
Last four digits, social security number 7297.
7291.
7291. I love the correction. You're on 25 CR 005 and 25 CR 0065. A motion for shock probation. You want to proceed?
Yes, Judge, it's two cases, as you said. It's a 6-year overall sentence, 5 and 1. Mr. Brooks has been down at the Class D facility for some time now, working essentially 40 hours a week, doing very well. There is $1,100 restitution in one of these, I believe. I don't remember which one it was, Mr. Stockton, but you mentioned restitution in one of them. He has plans. He doesn't have a job lined up, but he's a hard worker and he's confident he will have one lined up soon once
I actually have
he's released.
a bed lined up at the sober living facility here in Cumberland County. And she said they have job placement, so I don't think it would take very long to get a job. And she already
What
had a bed.
are the two underlying charges?
Your Honor, he had, the first charge was a forgery 2nd degree where he forged Bradley Watson's name on a check. And while he was on probation, I believe he was in drug court, he had sold David Schultz something and he changed the amount of the check from $400 to $1,400. That's where the $1,000 is coming in on restitution. I guess it's the bank that's probably owed that money. And that was the reason for the termination and the revocation on the probation. He does have a 6-year sentence. He's got about 8 months, almost 9 months in, and he's parole eligible in November of this year.
What's your position?
Well, he could probably, if he had a job and he had direct deposit and he couldn't be around any checkbooks, he might make it. But other than that, I don't know. That's really, he's never given any problem other than the altering checks. And I don't know how when somebody's dealing with a case involving dishonesty and deceit, I don't know how he's going to do if he gets out on shop.
What is the restitution about? To the bank?
I guess so.
No.
I'm sure that the bank probably made the victim whole in this.
Yeah, I'm sure on Mr.
situation,
Schultz's case, it's the bank. I don't know about Mr. Watson's case. I'd have to look and see. That's only $100 compared to $1,000.
Where is the sober living facility in Cumberland County?
How about State Park?
Yeah.
It's Chastity Davis.
Well, I'm going to take this under advisement. I want you to get a little bit more detail about what kind of job he's going to have, where he's going to be placed. Okay. And if you can convince a Commonwealth attorney, the fact that he's capable of working doesn't mean that he will work. I don't really, I don't want you to answer this. This is what you call a rhetorical question.
Yes, sir.
When do you decide it's all right to alter a check and steal somebody's money? I mean, it's a rhetorical question. I don't want to answer to that. It's something that you ought to think about. I mean, your freedom is worth a lot. So if you can give him a placement that's approved, a regular job, and I'll enter a shock probation order if you do that. But I'm not just going to sign one and go out there and maybe you get something going on. Okay?
Yes, sir.
Okay. Dylan Cherry. Dylan Cherry. Commonwealth versus Dylan Cherry, 26CR0013. Are you Dylan Cherry?
Yes.
Good morning. What is the last four digits of your social security number?
9680.
Pardon?
9680.
680. Okay, you're here on a bond modification hearing. What do you have to say, counselor?
Judge, I think just generally speaking, we're still working on gathering some records.
What's the charge that he's being held on? Highest charge?
Assault second degree and criminal abuse first degree, 7 counts. So 7 class C felonies and a class B felony. Or class C, another class C felony.
And its co-defendant's already set for next month. She's not on this month's docket. I think his current bond is 25,000. He can make 10% of that.
Give me a little detail about the charge, Mr. Doctor.
This was a case where he had several children, him and his wife. They were living under horrendous living conditions in a mobile home. Basically, it wouldn't sound structurally. It's just kind of a rat hole. The kids tested positive for meth, and he's accused of kicking one of the oldest boy with a steel-toed boot. And so that's the accusations. And $25,000 doesn't seem like that high a bond to me.
Park approved surety is it? Or cash? Which one is cash?
Or 2 times
Where are
property.
the children placed now?
They're with his mother.
With it? And is that his wife? Is this Mr. Cherry's wife or
His wife is charged as a co-defendant. His mother is where the children have
with
been
the
placed.
grandmother? The children are with their
Yes.
grandmother. Okay, and is the wife is not out on bond. She's scheduled to be here next month.
Correct.
Yeah, the only reason Mr. Cherry's scheduled because of the bond here.
Yeah. Does Mr. Cherry did he have a job before he was arrested?
Where were you working at, Dylan?
For Lonnie Watson.
Where?
For Lonnie Watson. Watson's.
Logwoods or what?
No, he did remodels houses. I still have that job whenever I get
Where would
out.
you live if you get out?
Well, my house burned, so I'd have to live with my dad.
Would your dad live with your mom?
No,
Okay. Well, I don't really have a problem with a $25,000 clerk approved surety. If you live with your father and you still stay away from the children until we get this
Right,
resolved. Is that okay, Mr. Stockton?
Yes, with the curfew.
With the curfew, church work or the doctor, and you need to get some kind of statement from that where he'll be employed. I guess that kind of employment, you move from spot to spot, so we might want to put a bracelet on.
Yeah.
Bracelet, okay? Thank you. Is he scheduled next month for a regular?
We probably need to put him on for next month.
Okay, let's put him on for next month. If she's on for next month also, that would be July the 23rd. Do you want a negotiation day, Mr. Stockton?
Mr. Sheffield, it'd probably be the setting for July the 13th at 9 a.m. That way we can see where we are as far as proof goes.
Does she have a separate lawyer?
She does.
She's here.
Okay,
No, remember I can't remember her name, but it was,
Oh, she's not.
yeah,
Read
Greta, yeah.
Okay, I'm sorry.
okay, well, you want her there on July 13th also before the
No,
next?
she's got a different lawyer and she's not due back to court until the July date, so I'm afraid we'd mess everything up if we set her early. So let's just deal with her next month.
Okay, that'd be fine.
Yes.
James Flowers. I went versus James Flowers. This is 26CR0024 and 26CR0031. Are you James Flowers?
Yes.
Good morning. You were born in 1975. Last four digits, social security number 7390. You represented by Mr. Bell. What's the Commonwealth have to say in this case?
Think we have a felony plea, don't we, Mr. Bell?
We do.
The client gonna come around.
Yeah, I'm sorry. I thought you come over here, Judge. I thought you were coming up to read.
A motion's been tendered, says you wish to enter guilty plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntary given? You're gonna have to speak up because it's a voice activated microphone. The camera won't come on if you say so, okay? Are you the same person named in indictments number 26CR0024 and 26CR0031?
Yes.
Is your judgment impaired today?
No.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes.
Have you viewed the evidence the Commonwealth has against you? Believe you're fully informed about your case?
Yes.
You understand that you do not have to enter guilty plea today. You have certain rights under the Kentucky United States Constitution before I can accept the plea. I'm going to go over those rights and to ask if you understand. If you have any questions, you can step away and ask your attorney. You have a right not to testify against yourself. No one can make you say anything right to speak in trial, but jury right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charges, and you understand it by entering a plea of guilty today. You give up those rights. You understand that?
Yeah.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept the recommendation. Prior to accepting your recommendation, I will await the pre-sentence investigation report from probation and parole event. And I decide to impose a harsher penalty. You have the right to withdraw your plea. Go to trial. Understand that? Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to possession of controlled substance first degree in case number 26CR31, the defendant shall receive a sentence of 1 year. Upon a plea of guilty to operating a motor vehicle with alcohol concentration of or above 0.08, or while under the influence of alcohol or other substance, fourth offense in case number 26CR24, the defendant shall receive a sentence of 5 years. Upon a plea of guilty to failure to maintain insurance on a motor vehicle in case number 26CR24, the defendant shall pay a fine of $500 plus court costs. The fine and court cost is to be paid at the discretion of the court. These two sentences are to run consecutively for a total of 6 years, serve 120 days. Balance shall be probated for 5 years. Probation is to be supervised. The defendant agrees to enroll and complete a long-term treatment facility. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky. And Mr. Bell informed us that he may have some type of proof on the insurance, but he'll have to provide that before sentencing, and we can amend the insurance charge if there is proof that shows that he had it at the time.
Is that your understanding of the Commonwealth's recommendation?
Yeah. Are
you pleading guilty because you did commit the acts charged in the indictment as amended? You're doing so of your own free will? I mean, constitutional rights explain to us your desire to give up those rights, enter a plea, and allow the court to fix your punishment. Is that correct? You understand that by entering this guilty plea, if you have future convictions of felonies, they can be enhanced under persistent felony offender law. Do you understand that?
Yes.
Set your signature on the document.
Yes.
I'll accept the agreement order of pre-sentence investigation report to be done by probation, parole, and scheduled sentencing on July 23rd.
Judge, would the court take into consideration placing on the order that there would be a preference for him to go to the Mark Center? They're a DOC facility, and I've really had a lot of good luck with them helping people.
I can't. I don't think that would be appropriate for me to direct that, but I haven't had very much luck directing Department of Corrections to do anything, so.
Well, I was just asking that be a preference. It's not really part of the order, but the federal courts do it a lot, Judge. That's recognized that.
But my pay grade in federal courts.
Thank you.
Okay, thank you. Joseph Grider.
Got a bunch of things done.
Joseph Grider. Commonwealth versus Joseph Grider, 22CR0015, 26CR0035. Are you Joseph Grider?
Yes, sir.
Good morning.
Good morning.
Mr. Grider, were you born in 1982?
Yes, sir.
Last four digits, social security number 9076.
Yes,
We're
sir.
here on a pretrial conference on 0035 and a pretrial diversion revocation. on 00015. Do y'all have an agreement on this?
Yes, Judge, we've got a plea for the court to consider.
Felony plea?
Yes, Your Honor.
Just hold it there.
Yes, Your Honor, it's a felony.
Okay. Motion defense hinder says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person that we just identified in 26 CR 0035 and 22 CR 0015?
Yes,
Is your
sir.
judgment impaired today anyway?
No, sir.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
I believe you're familiar with the evidence the Commonwealth has against you.
Sure.
I understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. I'm gonna go over those rights with you. Make sure you understand if anytime you have any questions, step away and ask your attorney. You have a right not to testify against yourself. No one can make you say anything. Right to speedy trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence, right to call witnesses to favor, right to appeal this matter, higher court if you lose. The right to require the Commonwealth to prove beyond reasonable doubt that you're guilty of charge against you. Understand that by entering guilty plea, that you give up those rights. You understand that? Do you?
Yes, sir.
Okay, now may consider the Commonwealth's recommendation, but I'm applying range of sentence provided below. I don't have to accept the recommendation. Prior to accepting your recommendation, I will order a pre-sentence investigation report done by probation and parole. After reviewing that, if I decide to impose a harsher sentence, you have a right to withdraw your plea guilty to go to trial. Ms. Gordon Anderson, what's the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance, first degree, first offense, methamphetamine, the defendant shall receive a sentence of 3 years, probated for 3 years, supervised. The defendant agrees to enroll and complete the Cumberland County Specialty Court. Upon a plea of guilty to operating a motor vehicle while under the influence of a controlled substance or other substances, first offense, the defendant shall pay a fine of $500. The defendant shall pay all fines and court costs at the discretion of the court. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours of community service per week until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style cases disposed of in a manner that's consistent with the laws, the Commonwealth, and the holding agency.
Is that your understanding of the Commonwealth's recommendation?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes, sir.
You're doing so of your own free will.
Yes, sir.
Knowing your constitutional rights explained to it is still your desire to give up those rights, but entering a plea of guilty to the charges and allow the court to fix your punishment in the range permitted by law. Do you understand that after entering a plea of guilty, any future convictions will enhance the range of penalty under PFO? Is that your signature on the document?
Yes, sir.
Okay, I'll accept the agreement order pre-sentence investigation report, scheduled sentencing on July the 23rd. Dustin Humphrey. Dustin Humphrey. Good morning. Are you Dustin Humphrey? Okay, this is 26 CR 0029. Mr. Humphrey, were you born in 1989? Last four digits, social security number 5636.
Yes.
Okay, this is a pretrial conference. What do we have?
Judge, we have a plea for the court to consider a felony plea.
Okay, I've just been notified, Mr. Humphrey, that you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Are you the same individual that we just identified in 26 CR 0029? Is your judgment impaired today in any way?
No.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes.
Have you reviewed the evidence the Commonwealth has against you? Believe you're fully informed about your case. You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights. We'll go over the rights. If anytime you have any questions, step away from the podium and ask your attorney. And I'll go over them now. You have a right not to testify against yourself. No one can make the same thing. Right to speedy trial, the jury, right to be represented, counsel, jury trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, the right to call witnesses in your favor. The right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove that reasonable doubt you're guilty of charge against you. Understand that by entering a guilty plea, then you waive those rights. You understand that? Now, we consider the Commonwealth's recommendation, but I may apply any range of sentences right below. I don't have to accept the recommendation. Prior to accepting your recommendation, I will wait to pre-sentence investigation or report from probation and parole. In the event that I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. You understand that? Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to trafficking in a controlled substance first degree, the defendant shall receive a sentence of 7 years, served 6 months, balance probated for 5 years. Probation is to be supervised. The defendant shall pay court costs at the discretion of the court. The defendant agrees to enter and complete a long-term rehabilitation. The defendant shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with laws of the Commonwealth of Kentucky.
Is that your understanding of the recommendation?
I'm sorry, Your Honor, and the defendant shall remain on active supervision until any and all fines and court costs are paid in full and until further request of probation or parole.
Is that your understanding of the Commonwealth's recommendation?
Yes, sir.
Are you in a plea because you did commit the acts charged in the indictment as amended? Okay, you plead guilty of your own free will.
Yes, sir.
Knowing constitutional rights is still your desire to give up those rights and allow the court to fix punishment within the range permitted by law.
Yes.
Now, you understand that after any of this guilty plea, future convictions of felonies to be enhanced under persistent felony offender law. You understand that? That's your signature on the offer and the document. I accept the agreement order pre-sentence investigation board schedule sentencing on July 23rd. Austin Wright.
Judge, on Mr. Humphrey, he has to do 6 months of condition before he's probated. And maybe we can ask for this sentencing, but he's requesting a furlough. His car's, it's at
An impound.
the impound. He's got some personal items in it and he'd like to get those out.
Finance, through a finance company, so I'm trying to get it out so I can have them come and pick it up. That way I can have a chance of getting another car when we get out.
I don't have any problem with them coming and pick it up. If you got somebody who can get the stuff out of it.
Well, that's the issue. I don't know.
You need to talk Commonwealth.
That he does.
I mean, if you got something he's afraid somebody else to see that's in the car, it might be a problem.
Well, I'm sure that probably would have been
We might
discussed.
should just have the sheriff do an inventory search and then release his personal property. Can probably be taken by the.
Yeah, I'm just trying to.
Well, okay, well, you talk to Commonwealth. That seems like a good plan. Okay. Commonwealth versus Austin White. Well, that car might be like a box of chocolates. You never know what you're gonna get. You open it up, right? Commonwealth versus, are you Austin White?
Yes, sir.
Good morning. You're here on 26 CR 0018. Mr. White, were you born in 1999? Last 4 digits, social security number 8022.
Yes, sir.
What does the Commonwealth have to say on Mr. White's case?
That's a felony before you ask them.
Okay. I've just been informed you tendered motion says you wish to enter a guilty plea. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given?
Yeah.
Are you the same person named in 26 CR 0018?
Yes, sir.
Is your judgment impaired in any way today? Have you talked this matter with your attorney? Are you satisfied with his advice?
Yeah.
Have you viewed the evidence Commonwealth has against you, believe you're fully informed about your case? You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights. I'm going to go over the rights individually. If you have any questions, step away before you can ask your attorney. And I'll ask you at the end if you understand. You understand that by entering a guilty plea today, you give up the rights. You have the right not to testify against yourself, no one makes anything, rights to be tried by jury, and be represented by counsel at trial, confront and cross-examine all witnesses, produce evidence, call witnesses in favor of process issue. Fail to attend does right appeal this matter to our court. If you lose, right to private Commonwealth prove beyond a reasonable doubt that you're guilty of the charge against you. Now, I may consider the Commonwealth's recommendation in this case, but I may apply any range of sentence by law. You do understand those rights over it, correct? Okay. Now, prior to accepting your recommendation, all the way to pre-sentence investigation report to be done with probation, parole, and event, I do not accept the Commonwealth's recommendation to say impose a harsher sentence. You have a right to withdraw your plea. Ms. Gordon Anderson, what's Commonwealth?
Yes, Your Honor. Upon a plea of guilty to theft by unlawful taking or disposition over $1,000, the defendant shall receive a sentence of 5 years, probated for 5 years, supervised. The defendant shall enter and complete the Cumberland Specialty Court. The defendant shall pay restitution in the amount of $7,702.86 at a monthly rate of $150 per month to the Cumberland Circuit Court Clerk, with the first payment being due within 30 days from the entry of said plea and due on the same date thereafter until restitution and the clerk's fee is paid in full. Restitution is subject to a 5% clerk's fee. The defendant shall remain on active supervision through either Cumberland Specialty Court or probation and parole until both of the following conditions have been met. 1, successful completion of the specialty court, and 2, payment of restitution in full. The defendant is currently incarcerated and shall remain in custody until final sentencing and be released the morning of specialty court orientation. The defendant shall have no contact with the victim or victim's real property. The defendant shall receive credit for time served. The defendant agrees to have any and all contraband and controlled substances disposed of in accordance with the laws of the Commonwealth and the holding agency.
Is that your understanding? Okay. Are you pleading because you did commit that charge in the amended indictment?
Yes, sir.
Okay. Doing so your own free will.
Yes, sir.
Knowing your own constitutional rights to your desire to proceed on the court to fix your punishment. You understand that after entering a plea, future convictions could be enhanced as far as range of penalty under persistent felony offender law. You understand? Is that your signature?
Yeah.
Okay, I'll accept the plea. Do I need to sign any referrals to drug court?
There is a referral order as well.
I want to make sure we get it underway so you can get in it, okay? Okay, thank you very much. Do you have anybody else in custody with you? Okay, let's go to Alec, Jerry Compton. I want to put that Jerry Compton.
Morning, Rob.
Good morning. Are you Jerry Compton?
Yes, sir.
Good morning. You're on 26 CR0006. Mr. Compton was born in 1973. Last 4 digits, social security number 4287.
Yes.
What's the Commonwealth have to say?
We had a verdict and plea, Dron.
Motion been tendered says you wish to please, is that right, Mr. Compton?
Yes.
Are current under influence of drugs or alcohol? Is this plea freely and voluntarily given?
Yes.
It's the same person that we just identified in 26 CR0006.
Yes.
Is your judgment impaired today in any way? Is your judgment impaired? Okay, have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
Have you viewed the evidence the Commonwealth has against you? You believe you're fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights.
Yes.
You have a right not to testify against yourself. No one can make you say anything. Your right to speed trial, but your right to be represented by counsel at jury trial, the right to confront and cross-examine all witnesses, call testify against you, your right to produce evidence, right to call witnesses in your favor, right to appeal this matter, higher court if you lose, right to require the Commonwealth to prove on a reasonable doubt that you're guilty charged against you. Understand that by entering a guilty plea that you give up those rights. You understand that?
Yes, I understand.
And may consider the Commonwealth's recommendation, but I may apply any range of sentence provided law in prior to accepting any recommendations. I will have a pre-sentence in the event that I do not accept the Commonwealth's recommendation to decide to impose a harsher punishment, you have a right to withdraw your plea of guilty. I'm going to ask you some qualifying questions on your diversion eligibility. Have you previously been diverted in the last 5 years? Do you have any felonies in the past 10 years? Have any felonies in the last 10 years? Are you currently on probation? You understand if you successfully complete the diversion program, the charge will be dismissed, pretrial diverted, you can have your record expunged. You understand that? Okay, you understand if you don't complete the diversion program and brought back in front of me, and I rule that you violated it, you'd be a convicted felon that can be used against you in the future. What is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance, first degree methamphetamine, the defendant shall receive a sentence of 1 year, pretrial diverted for 1 year. The diversion is to be supervised. The defendant agrees to have any and all evidence in the above style case disposed of in a manner that's consistent with the laws of the Commonwealth and the holding agency.
Is that your understanding of the Commonwealth's recommendation?
Yes.
Are you pleading guilty because you did commit the act charged in doubt?
Yes.
Doing so your own free will. Know your constitutional rights to explain this, it's still your desire to give up those rights and plead guilty on the court fix your punishment. Is that your signature on the motion, Al? Is your signature on there?
Yes.
I'm gonna accept the agreement and sign it.
Yes, sir.
What's the court cost in this case?
$245.
You need some time to pay that?
Yes, sir.
Okay, I'll let you pay it at $40 a month, the first payment due 30 days from today. Okay. You don't need to meet with the probation and parole officer there. Thank you very much. Javonda Cundiff.
We'll put her in NCIC on.
Stephen Eaves. This is 26 CR 0032. Are you Stephen Eaves? Good morning. Were you born in 1981?
Yes, sir.
Last four digits, social security number 5393.
Yes, sir.
What's the Cumberland?
Your Honor, he has a co-defendant, Cheryl Silva. She now has conflict counsel, so I want to get a pretrial conference and a negotiation day for both those cases.
Okay, let's call, is conflict counsel here?
Yes, sir.
Cheryl Silva, we'll just bring you up now at the same time. Negotiation day would be on.
July 13th, yeah.
July 13th. You are Cheryl Silva, is that correct? You acknowledge that her identity, so we'll have to go through that. July 13th for negotiation day. Next court date is July the 23rd. Is discovery complete in this?
It is, and we need her attorney's address, email address, so we can put you on docket share.
Thank you. And I did have a tiny issue with discovery, but I'll talk to your
That's fine.
spirit system.
Tiny issue.
It's just
I can handle tiny issues like it. Can you handle a tiny issue today?
Yeah, I thought it was like a Johnny Bell or King Garrett issue.
Yeah.
Okay.
Okay. Okay, well, thank you. Y'all be present on those days. Both those are conditions to your bond, okay?
Thank you.
William Owsley. William Owsley. Commonwealth versus William Owsley, 26 CR 0025. Are you William Owsley?
Yes, sir.
Good morning. You were born in 1966.
Yes, sir.
Last four digits, social security, and 9744. What does the Commonwealth have to say, Mr.
He
Owsley?
had Mr. Shuff at the last court appearance, and I think Mr. Bell's representing him now, so we'll need a negotiation day. and a pretrial
Negotiation date on July the 13th. The next court date is on July 23rd. Both of them are conditions of your continued bond. Okay?
Thank you, Judge.
Jackie Powell. Jackie Powell.
Good morning, Judge.
Good morning. Commonwealth versus Jackie Powell.
Judge, this is approaching. Very still.
26 CR 0028. Mr. Powell, you are Jackie Powell?
Yes,
Good
sir.
morning. You were born in 1971.
Yes.
Last four digits, social security number 5979. Represented by Mr. Steele. What's the Commonwealth have to say?
Mr. Steele got in his case, and he was out of town the last negotiation day, so he can be present the next one. We will need a negotiation day and pretrial conference.
Negotiation day for July the 13th at 9 AM here. And the next court date is July the 23rd.
Judge, I have a trial scheduled in Boyd County on the 23rd.
Well, come to the negotiation day, and if you have a plea or something, we might accommodate you at one of the other venues so that you just go around that, and trials sometimes get continued.
I'm
So we'll just go ahead and leave it on the 23rd now, and with the knowing that we'll accommodate you. Okay,
Yes, sir.
Okay, thank you very much.
But Judge, if I could address one matter, he's currently on the condition of his bond. He's got some medical appointments that he's going to be, basically on house arrest. But he does need to do some medical appointments and some bank. He still does banking.
I have, the conditions of my bond are church, doctor, or work. So all he's got to do is notify him on any kind of medical situation. What else does he have?
It's his father, he was living with his father. He was the caretaker of his father. His father's now out in Washington. However, his father's banking is still done here. So his sister is asking him if they can do. His father has Alzheimer's, Judge. And so.
Well, what do you tell me that he wants to do?
He needs to be able to go to do some banking for his father.
I think he needs to go to the bank and get everything transferred to Washington. It sounds like that's his sister.
One of the things that's gonna be tough.
Well, I don't, if he needs to go to make an isolated trip to the bank, he just needs to call the folks at the bond and say he's going to the bank.
That's great. Thank you. Thank you, Judge.
You don't want you to go regularly to the bank back and forth, okay? No
Thank you.
problem. Okay,
Thanks.
no problem. Franklin Robinson. Franklin Robinson. Frederick Robinson. How about versus Frederick Robinson? Are you Frederick Robinson?
Yes.
Good morning. This is 26 CR 0033. Mr. Robinson, were you born in 1973?
Yes.
Okay, the last 4 digits of social security number 0103.
Yes.
What does the Commonwealth have to say about Mr. Robinson?
Well, the last thing I knew, we made an offer and I hadn't gotten a response. I didn't know if we had any fruitful negotiations to look forward to, or if we need to try.
I think we do. If you remember, I had some issues I wanted to look into to see if I needed to explore potential motions.
Negotiation day,
Yeah, I'll get do one more, yeah.
July 13th, the negotiation day. The next court date is July 23rd, and both of them are conditions of your bond. You discuss, make sure you get a hold of your attorney so you'll be available, so you know what's going on as far as the negotiation day, okay? Candace Seamos. Is it Seamus or Simus? Seamos, okay. Candace Seamos, 25 CR 0076. Ms. Seamos being born in 1985.
Yes, sir.
Last 4 digits, social security number 7517. You have listed Ken Garrett as your attorney. What's the story here? Okay, they say he's running behind, so you just have a seat and we'll call you, get your case back up. Cody Stinson,
He's still in the U of L hospital, Your Honor.
okay. Okay, we have 21 minutes. We got one case in the Clinton County Jail. Is Clinton County Jail on there yet? Are y'all on yet? Okay, well, let's go off the record here. Just for a minute here, we'll wait for. You want to put Mr. Stinson back on for next month, or just continue it generally for you to redock it?
That's fine, we can redocket it. As long as they keep the clerks updated.
Well, let's just put him on next month. That
Yeah,
way.
that
We'll
way
bring
we
that,
know.
okay, next month. Which will be on July 23rd. Okay, are we off the record now? Let's go off the record here. And I guess I need to go over here. Is this correct over here? I need.
Yeah, Lane, underneath paper.
CR 0076. Commonwealth versus Seamos. Mr. Garrett, thank you for joining us. You have a plea agreement?
I do, Judge.
Yeah.
Yeah.
No, I'll tell you when to just hang out there. I want to identify our signature. Okay. A motion's been tendered, ma'am, that says you wish to enter a guilty plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, you're,
Is this plea freely and voluntarily given?
yes, sir.
Are you the same person that we just identified in 25 CR 0076?
Yes, sir.
Is your judgment impaired today in any way?
Not at all, Your Honor.
Have you discussed this charge with your attorney? Are you satisfied with his advice?
Yes, Your Honor.
Have you reviewed the evidence Commonwealth has against you? Will you fully informed about your case?
Yes, Your Honor.
You understand that you do not have to enter a guilty plea today. You have certain rights under Kentucky and the United States Constitution. Before I accept the plea, I need to know that you understand those rights.
Yes, Your Honor.
You have a right not to testify against yourself. No one can make you say anything. Right to speedy trial, but you're right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. You understand that by entering a plea guilty, you give up all those rights. Is that
Yes, Your
correct?
Honor.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept any recommendation. Prior to accepting any recommendation, I'll await the precinct's investigation for information parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Do you understand that? What is the Commonwealth's recommendation, Mr. Dodd?
Your Honor, Ms. Seamus will plead guilty to operating a motor vehicle, first offense under the influence, $200 fine and cost. She'll also plead guilty to trafficking in synthetic drugs, first degree, receive a sentence of 2 years. Also trafficking marijuana, sentence of 2 years. They shall run concurrently for a total of 2 years. In accordance with KRS 218A 1430, in lieu of a fine, the defendant shall pay $2,500 to the Cumberland Circuit Clerk with 15% diverse to the Commonwealth Attorney's Asset Forfeiture Fund, 85% dispersed to the Cumberland County Sheriff's Office. That'll be paid within 25 days of the entry of the plea. The defendant shall receive credit for time served. And that's statute dealing specifically with synthetic drugs.
How much time does she have to serve?
I don't know that she's got any time. That's,
There wasn't any time to serve on.
no, there's no time to serve.
She got money up on that bond that we can use for that forfeiture.
Yeah.
Let's go over the sentence again.
It's 2 years for 2 years, pretrial diverted with a $2,500 fine, basically.
I wasn't dealing with diversion here. I was looking at the other. I thought it was just straight guilt.
No, it's a diversion. I'm at a loss because I thought in my file I had it packed, but it's not.
Yeah, I just printed this off early this morning.
Yeah, it's a diversion.
Okay. Do what? Let's go back and start all over again. Okay. Okay, there's a diversion on the felony plea, but there is no diversion on the DUI.
That's correct.
Obviously. Okay. Okay, I'm gonna go over your rights with you again. You have a right not to testify against yourself. No one can make you say anything. Right to speed trial, but you're right to be represented by counsel at jury trial. Right to confront and cross-examine all witnesses called to testify against your right to produce evidence. Right to call witnesses in favor. Right to appeal this matter to higher court if you lose. And right to require the Commonwealth to prove unreasonable doubt you're guilty of charges against you. By entering this guilty plea, you give up all those rights. You understand that? I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. If I don't accept your recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea, go to trial. I'm going to ask you some qualifying questions on the pretrial diversion. Have you previously been diverted in the last 5 years?
No, Your Honor.
You have any felonies in the past 10
No, Your
years? Are you currently on probation?
No, Your Honor.
You understand if you complete the diversion agreement, the charges will be dismissed, pretrial diverted. You understand that? But if you do not successfully complete diversion, you're brought back before the court will schedule a sentencing hearing. You'll be a convicted felon that can be used against you in another felony. You also understand that on the DUI plea, if that's enhanceable, if you get another DUI, that can be used to enhance the penalty. You understand that?
Yes, Your Honor.
You've heard the Commonwealth's recommendation. Is that your understanding of the recommendation?
Yes, Your Honor.
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes, Your
Are
Honor.
you doing so of your own free will?
Yes, Your Honor.
On your constitutional rights to explain to you is it still your desire to give up those rights and allow the court to fix your punishment within arrangements made in the law?
Yes, Your Honor.
Is that your signature on there?
Yes, Your Honor.
I'll accept the agreement and sign the diversion order. Now, do you have the DUI papers down there?
Judge.
Okay, now what are the total costs?
It's $855 plus that 2,500. She's got 2,500 posted.
Plus the 5%. On the 2,500, I think.
Are you doing 5%?
With 5% of just straight going. I think it's, since it's more like a fine, I don't think it would be 5%. It just goes as a court.
Well, wait a second. How much money does she have?
$2,500.
Okay, and that goes at a forfeiture, or is it a fine?
No, that is a forfeiture.
It's a forfeiture.
treated like a forfeiture.
Under the statute, it's treated like forfeiture. I misspoke.
Forfeiture, okay, now, so she got enough to do the forfeiture, and what are her court costs on top of that?
$855.
Okay, when can you pay that?
Judge, could you give her like 90 days to pay that other amount?
No,
How much time could you give her?
well, I mean, which am I supposed to take out first, you know?
I think it's your discretion.
Well, I know, but I think there's a statute on which comes out.
Well, we just can release that bond until it's over.
That's, okay, so I'll allow her to pay, $150, let's say, 800 something, let's say 250, about $300, 30 days from day, and $300 30 days after that, and final 30 days after that, okay? And then it can be released. The rest of it can be released. 300, 300, and 2 whatever, okay? Okay? Okay, you need to meet with the probation and parole officer. Were your driver's license picked up?
Oh, yeah.
Are we supposed to pick her driver's license up on the DUI?
Tennessee license.
So her privilege is suspended here, but she'll have.
She has a Tennessee license.
She does. They'll send her a letter, I think.
Oh, they will send her over to Tennessee, sure. Okay. Okay, let's go. Is Clinton County Jail on there? Still 2 minutes. What have you got?
I was Clayton County Jail,
Are they on there?
Sam.
Okay, well, let's go to Dyer County. Let's go to Dyer County, and if y'all kind of watch Clinton, if they come up, we'll start taking them. There. In Dyer County Jail, you want to turn your camera on?
Well, I've tried to turn it on. It won't come on. It says, the host has, asked. Okay, I'm trying. Sorry about that.
Okay.
Let me get you guy here.
Terry Aaron? Are you Terry Aaron?
No,
Brian Thompson.
it's Brian Thompson. Okay, must have got another one from up there at the other jail. Well,
You're 30 minutes early on the Dyer County, so the other facility may not be.
Clayton County just came in.
Okay, well, I guess we're a little early on the Dyer County. I thought y'all might be ready. Let me come back to you just a second. I'll go to the clinic.
Okay, we are in Dare County, but we're the Class D facility with Brian Thompson.
We can take Mr. Thompson up.
Okay, well, let's go ahead and do Mr. Thompson. They're not separated on my docket sheet here. So we'll go ahead and do Mr. Thompson, okay?
Thanks, sir.
Commonwealth versus Brian Thompson, 26 CR 0027. You're here for sentencing. Mr. Thompson, were you born in 1980?
Yes, sir.
Last four digits, social security number 4324.
Yes.
Can I have the sentencing document? Mr. Thompson, if you had an opportunity to look at the pre-sentence investigation report done by probation, is this
Yes.
substantially correct? Counselor, is any reason this gentleman should not be sentenced?
No, Your Honor.
On a plea of guilty, possession of controlled substance, first degree meth, the defendant shall receive a sentence of 1 year. The sentence is run consecutively to Cumberland Circuit Court case number 20 CR 00066 for a total of 4 years to serve. The defendant shall pay court costs at discretion. Considering the length of the sentence, I'm going to waive the court costs. The drug paraphernalia shall be destroyed. Okay. Thank you very much. And do you have anybody else at that facility that we have on the docket today?
Not here. No, this is the only one other than Mr. Brooks that he showed up down there this morning.
Mr. Brooks came from there as well, but he was in person.
Okay, thank you very much. We'll come back to their regional jail.
I'll give him a call.
Thank you very much.
All right, thank you.
Yeah. Clinton County, turn your camera on.
Done? Yes.
Okay, I'm calling Ricky Purdue.
Yes, sir.
Are you Ricky Purdue?
Yes, sir.
This is 25 CR 0067. Mr. Purdue, we're here for sentencing. Were you born in 1981?
Yes, sir.
Last four digits, social security, 1284.
Yes, sir.
You had an opportunity to look at the pre-sentence investigation report done by probation and parole.
Yes, sir.
Substantially correct.
Yes, sir. As far as my knowledge.
Is there any reason why this gentleman should not be sentenced today?
No, Judge.
Upon plea of guilty to wanton endangerment, first degree, 2 counts, he shall receive 5 years on each charge to run concurrently for 5 years. Upon plea of guilty to operating under the influence of alcohol, aggravating circumstance, he shall serve 14 days and pay a fine of $350. The sentence is to run consecutively to Clinton Circuit Court number 26 CR 0037 for a total of 6 years. The court, what are the total court costs?
$1,005.
$1,005. You can start paying it at $40 a month on 30 days after your release from incarceration. Now, you did understand when you entered the plea that the DUI is enhanceable. If you got another DUI, you understood that. Is that correct?
Yes, sir.
The same thing on the felony counts. They're enhanceable under persistent
Yes,
felony. Okay. Thank you very much. Clinton County, you're excused. I think that's the only thing we have on the docket. Thank you for cooperation. Now, I guess the Dare County is on there. Are y'all ready to start your docket up in the Dare County Regional Jail? I know we're 30 minutes early, but.
Yes, sir. We're all here. We're all accounted for. We're ready.
Oh, well, thank you. Let's go ahead. Commonwealth, ready to proceed?
Yes.
Okay. Defense, ready? You ready to proceed?
Yes, Judge.
Okay, let's call Terry Aaron, please. Terry Aaron. Commonwealth versus Terry Aaron, 25 CR 0081. Terry Aaron.
Yes, sir.
Good morning. Were you born in 1987?
Yeah.
Last four
Yes,
digits, social security number 6691. Okay.
Yes, sir.
What's the Commonwealth have to say in this case?
Your Honor, Mr. Aaron has is on felony probation here on a possession of
I
controlled
think
substance.
you're probably going to need to come over to this central.
Is it not picking up?
It's not picking up for some reason, Mr. Stockton. Go ahead. I'm sorry.
Mr. Aaron is on felony probation in Cumberland County on possession. He has 3 year sentence. He's got a new possession charge in Metcalf Circuit in Metcalf County. And he had a traffic stop and he had a clear baggie presumed to be meth. I don't think there's a lab back yet. And that's the basis for the revocation. I think Mr. Sheffitt's requested that he be assessed for drug court. I don't have a problem with that. And that will give me time to consult with Mr. Gardner and see what he wants to do with the case.
That's our request, Judge.
Well, I do a referral to drug court subject to any intervening action that they might take over in, was it Metcalf or Bryant?
Metcalf, so it'll be John
Metcalf
Gardner's
Okay.
case.
So you want to schedule this for,
Could we have that on negotiation day and also the court day? That way I'm informed. Mr.
July the
Sheffitt what I found
13th
out.
for negotiation and July 23rd, the next court date. So what they're trying to do is see if the Metcalf County Circuit Court be willing to go along with a drug court situation. Your attorney will be back with you, Mr. Aaron, okay?
Thanks, sir.
Okay. Louis Arms. Commonwealth versus Louis Arms, 21 CR 0058 and 21 CR 00137. You are Louis Arms?
Yes, sir.
Good morning. You were born in 1964. Last four digits
Yes.
of Social Security number 8381. Is that correct?
Yes.
Okay, what does Commonwealth have to say? Probation revocation?
Yes, it is, Your Honor. Motion to revoke probation. Mr. Arms in 21 CR 137 has a burglary third of 4 year sentence. 21 CR 58 has possession, controlled substance, 3 year sentence for a total of 7 years. And he has a new possession case here in Cumberland County that's going to the grand jury today. So I thought Mr. Sheffitt might want to put that on the negotiation day and see if we can wrap all that up at one time.
That's fine, Judge.
And we'll send him the link for the discovery on the possession.
Okay, we have a negotiation day on July 13th. The next court appearance will be July 23rd. Mr. Arms, they say they got another session case. You heard that. So they're going to try to get it where they can wrap all your stuff up, and you'll need to do a transportation order for him to bring Louis down here on the 13th for negotiation. Okay.
And Judge, I did want to make the court aware, he does have a what appears to me, in my amateur eye, a pretty severe medical issue, a hernia that's very pronounced.
Well, let's don't talk about that online here. If he's got some medical needs or something, talk to Commonwealth attorney. I've known Mr. Arms for a long time.
If he needs a furlough or whatever, let me know.
Okay, so we'll, if there's some medical treatment or some accommodation, we'll try to do it by agreed order so we'll protect his privacy. Okay, thank you very much. Thank you, Mr. Arm. Commonwealth versus Joseph Bryant.
Chad,
Good morning. Are you Joseph Bryant?
Yes, sir.
It's 26 CR 0026. Mr. Bryant, were you born in 1974?
Yes, sir.
That's 4 digits, Social Security number 2971. We're here on a
Yes,
pretrial conference. What does the Commonwealth have to say?
Your Honor, Mr. Cross and I have met on this case. It's a severe case involving sexual abuse allegations. And gonna ask the court if we could get an order to mediate the case. I'm trying to get approval from PAC to mediate certain cases based on my asset forfeiture funds. So, and I think Mr. Cross is in agreement if the court is. Which is, it's a nominal amount to pay, but I don't think it's ethical for the defendant to pay all the costs of mediation. So I'm waiting on an answer from Prosecutor's Advisory Council.
Do you want to schedule this for a negotiation day, or are you just going to continue it generally until y'all sit the?
Yeah, maybe we could set it in August. Would that be too far out? August, yeah. Because hopefully we'd have it mediated by then. If not, we can get a trial date if it's not resolved based on the allegations. It's not.
August the 27th. What's your negotiation day in August?
We've not set one yet.
Okay, just have it August the 27th, and if you need a negotiation day, you can do it by the order.
That's fine.
Okay, thank you very much. Amy Cropper. Amy Cropper. Commonwealth versus Amy Cropper, 26 CR 0020. Are you Amy Cropper?
Yes,
What's your year of birth, Miss Cropper?
1981,
Last four digits, social security number.
3772.
You had an opportunity to look at the pre-sentence investigation, report number, probation, parole.
Yes, I did.
Substantially correct.
Yes.
Counselor, is any reason this lady should not be sentenced today?
No,
No.
Judge.
On a plea of guilty, possession of controlled substance, first degree, third or greater offense, the defendant shall receive 3 years probated for 3 years probation to be supervised. She shall enroll in complete long-term rehab center outside the immediate area. What's the court cost?
$245.
$245. I'll allow you to pay that $30 a month, starting 30 days after your release. Now, has there been before, probation is enacted and, she gets out, have you lined up the long-term rehabilitation center outside the immediate area?
Judge, we're working on that. There are some complications. If I could approach, I could tell the court what they are.
Tell the Commonwealth what they are. Go back there.
Your Honor, I got an answer for you on that.
Wait just a second.
Okay.
Uh,
Stepworks called me yesterday and said that they would be taking me in.
Well, that's information that I didn't have as about 6 o'clock last night. Our social worker didn't have been turned down by a couple that we thought we had.
Okay, well, you just find out the information, verify what this lady said and get with the Commonwealth. We can make it move on, okay? Your attorney will be with you and he's gonna talk to Commonwealth about getting that information verified from the organization, okay?
Okay, thank you.
Thank you very much. Heather Edens. Commonwealth versus Heather Edens, 26 CR 0038 for arraignment. Are you Heather Edens?
Yes, sir.
Good morning. This
Good
is 26 CR 0038. You're here for the purpose of arraignment. You're represented by counsel. You have the right to remain silent. The grand jury of Cumberland County has returned an indictment charging you with violation of 507.020 murder. Counselor, do you acknowledge the identity of your client, receive indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
Okay, now, considering the nature, I'm signing a reciprocal discovery order, ma'am, which will require the Commonwealth to give your attorney all the evidence that they have that's discoverable to help you prepare for your case. Is it too early to set a negotiation date in this thing?
I haven't seen any discovery yet. I know I've seen the preliminary hearing, so I have some idea, but I mean, we can set it.
Well, let's set a negotiation date. If you're not ready to proceed with negotiation, you can enter an agreed order with the Commonwealth and we'll continue. The negotiation date is set for July 13th. The next court date is July 23rd. What is her bond presently?
$100,000 cash.
Okay. Okay, well, your attorney will be up to see you, Ms. Edens, okay? Thank you. Tia Hancock. Tia Hancock, and I want Ms. Edens in considering the nature of the charge. We need her transport from here on out, okay? Tia Hancock.
Yes.
Are you Tia Hancock?
Yes.
Good morning. This is 20 CR 0025. Ms. Hancock, were you born in 1992?
Yes.
Last four digits of your social security number 2575.
Yes.
You're here on a probation revocation.
Yes.
Let's come up and say.
Your Honor, she has a 3-year possession sentence here in Cumberland County. Also, a tampering physical evidence from Dyer County, 5 years. She had a new felony arrest in Cumberland. We just got the case this morning from the officer, so it can't go to the grand jury today. It'll go next month. It's a possession of controlled substance. She's a drug court graduate here from 2024. So I don't know if Mr. Sheffitt wants to go ahead and try to negotiate this with the new case and doing information, or if he wants to wait on the grand jury next month.
Well, I don't know. Then after that, I have not seen or really know anything about the new case, but it can't hurt for us to give it a
Okay,
shot.
let's set a negotiation day for July the 13th and next court date for the 23rd. And if you don't have sufficient discovery by the 13th to participate in negotiation after having fully informed your client, you can.
And I know there's not we don't have the laboratory, so.
Okay. Okay, thank you very much. Your attorney will be to see you, man. Dustin Hayes.
Dusty.
Arraignment. Commonwealth of Kentucky versus Dustin Hayes, 26 CR 0037 for arraignment and 21 CR 00138 for probation revocation. You are Dustin Hayes.
Yes, sir.
Good morning. Were you born in 1986?
Sir.
Last four digits social security number is 7836, correct?
Yes, sir.
You have a right to remain silent during this arraignment. The grand jury of Cumberland County has returned an indictment charged with possession of controlled substance, first degree, second offense, assault in the fourth degree, and possession of drug paraphernalia. You understand those charges?
Yes, sir.
Counselor, you acknowledge the identity of client received the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay, we'll schedule a negotiation day on July the 13th, next court date. Thank you. On July 23rd, I'm signing a reciprocal discovery order, sir, that requires the Commonwealth to give you the information they have to help inform you for negotiation and prepare for your defense, okay?
Okay.
Okay, James Hurst.
Tommy.
Commonwealth versus James Hurst. 22 CR 0013 and 22 CR 0038. Are you James Hurst?
Yes, sir.
Good morning. Were you born in 1970?
Yes, sir, I was.
Last four digits social security number 2119. You're represented by Mr. Garrett. What's the Commonwealth have to say?
Your Honor, Mr. Hurst has a motion to revoke shop probation. He's got 5 years on 22 CR 13. And for T-Butt, he's got 22 CR 38, 5 years for traffic and controlled substance. That's a 10-year sentence when they were run together. Basically, the allegations of the revocations were that he absconded. The probation officer in December of 25, I think the probation officer was aware. Mr. Garrett's handed me a bunch of medical records this morning. That he went into the hospital sometime in January, but he evidently never did report back during the pendency of this. So I don't know if I need to look at these medical records or if the court wants to go ahead and have a hearing. I'll do either one.
We can give him some time to look through those, Judge, and I'd like to talk to him.
Okay, well, let's just put it on the docket. You want a negotiation day on this, or you just want? to
No,
put it
I'm
straight on
ready.
the docket?
I'm ready to proceed the revocation. I mean, whenever the court's ready.
Yeah, whatever they want to put, Judge, it's fine.
Do you want to do it today? or-
Well, I'd like to look at these, but it
Okay,
looks
well,
like
let's
they're all
put it on
records
next
from.
month. Put it
Okay.
on next month, since you didn't receive it until today. July the 23rd, the revocation hearing for Mr. Hurst on 22 CR 0013 and 22 CR 0038. Your attorney will be over to talk to you, Mr. Hurst.
Thank you, Your Honor.
Jennifer Moore. Since Are you Jennifer Moore?
Yes, sir.
Good morning.
Good
This
morning.
is 25 CR 0080. Ms. Moore, you born in 1982.
Yes, sir.
Last four digits social security number 8379.
Yes, sir.
Have you had an opportunity to look at the pre-sentence investigation report done by probation parole?
Yes,
Is it substantially correct?
yes,
Counselor, is there any reason this lady should not be sentenced today?
No, Judge.
On a plea of guilty to convicted felon in possession of firearm, the defendant shall receive a sentence of 3 years. Explain the probation on this firearm to me, Mr. Stockton.
This is a case where there was a domestic altercation, I believe. And when the police responded to the scene, what happened was Miss Moore was in her home. She had had a live-in or a significant other evicted from that home. And that person wanted some of his personal property back, so he broke into her home. When the officer responded to the complaint, he found that she had a shotgun, I believe, in her bedroom. I'd have to look at the file to be sure, but I believe it was a shotgun. And he arrested her because she was a felon in possession of a firearm. So that's the reason for the break in this case.
Choice of evil.
Choice of evils.
And I would add this, it occurred in April 2022, but wasn't indicted until November of 25.
Yeah, I don't know why.
Probation is to be supervised. The defendant shall be released at final sentencing. What is the court cost?
$190.
You need some time to pay that, ma'am?
I can have it paid within 30 days. I'm
I'm
on
gonna give you
SSA.
longer. I'll give you longer than that. You pay the first $30 in 30 days and $30 thereafter till you pay the 190 in full, okay?
Yes, sir. I can do that.
You want her to come to see the probation office up there? She's gonna be released today.
She's released today, Your Honor. She's in there, and she can come to my office even if she's released.
Okay, what time you want?
Aim for 1.
Okay, we'll release you at 1 o'clock today. If papers get up there, you go straight over to the probation parole office, okay?
Yes, sir. I can do that.
Okay, thank you.
Thank you, sir.
Carrie Pendergrass. Commonwealth versus Carrie Pendergrass. 26 CR 0030. Are you Carrie Pendergrass?
Yes.
Good morning. You're here. Were you born in 1989?
Yes.
Last 4 digits, social security number 7964.
Mm-hmm.
Okay, this is 26 CR 0030 pretrial conference. What does the Commonwealth have to say?
Well, I've made 2 offers in this case, Your Honor. I don't know if you're going to accept either one of them or not.
Judge,
What's the charge you offered?
Basically, she's, her mother took out charges against her because she took her, I don't know, about a $50,000 Hyundai or Kia and left Dunlap, Tennessee and drove it up here, and she got arrested up here for theft. Probably the correct charge up here should be receiving, the theft charge should be in Tennessee. And I've offered her, based on my conversations with her mother, either a year to serve or probation and we released it since.
Judge, the probation offer came this morning, so I hadn't had a
That's
chance
correct.
to talk to her about that.
And the offers have been more severe because her mother's kind of been more merciful in this case. It's
So
all
if we could set this over for next month and we'll take a shot at resolving it, I think.
July 23rd. Your attorney will be able to talk to you, Mr. Pendergrass.
Thank you.
Jordan Scott. When we bring Ms. Pendergrass case back up, I want to know the circumstances of how she was arrested and whether she was, like in flight, that sort of. See what I'm saying is more a matter of public safety here in Kentucky, no matter what her mother has to say.
Well, I knew she didn't have any insurance or something like that, some traffic violation.
Are you Jordan Scott?
Yes, sir.
Morning. This is 26 R 0038. You're here for the purpose of arraignment. You have the right to remain silent. Mr. Scott, were you born in 2002?
Yes, sir.
Last 4 digits, social security number 3365.
Yes, sir.
You have the right to remain silent. The grand jury of Cumberland County has charged you with strangulation in the 1st degree and assault in 4th degree. You understand what those charges are?
Yes, sir.
You acknowledge the identity of your client, receiving the indictment, waive formal reading and arraignment, enter plea of not guilty.
Yes, sir.
All pre-trial motions.
Yes, sir.
Scheduled negotiation day on July the 13th. Next court appearance July 23rd. Sir, I'm scheduling I'm signing a reciprocal discovery order requiring the Commonwealth to give you the information necessary. After your defense, your attorney will be back over here and we'll need transportation orders to bring you back down for negotiation. Clay Smith, your attorney will be able to talk to you, Mr. Scott. Clay Smith. Commonwealth versus Clay Smith, 22 CR 0050. Are you Clay Smith?
Yes, sir.
Born in 1999?
Yes, sir.
We did Social Security number 3796.
Yes, sir.
Pretrial diversion revocation. What does the Commonwealth have to say?
Your Honor, Mr. Smith has a 3-year sentence. He's pretrial diverted for 5 years. He's a drug court graduate from here in Cumberland County. I think Mr. Payne had a community complaint and Mr. Smith came in and admitted to drinking on the weekends for at least a month. And I've got Mr. Payne on to testify if I need to.
What do you recommend?
I'm recommended, I think he had a problem with the law in Tennessee and we've had several community complaints. I think he should be revoked at this point in time myself. But Mr. Payne's on the line if you want to hear what he happened at the probation office.
Judge, I don't think we have a discrepancy in facts, but obviously, I think this is something that can be handled short of revocation.
Let me see what Mr. Payne has to say about these other things. The alcohol in and of itself probably should be a sanction, but if there's a larger problem, I want to know about it, okay? And then if it goes beyond the scope of the motion for revocation, I'll give you some time to investigate. That sound fair enough?
Yes, Judge.
Okay, Mr. Payne, you raise your right hand. You swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
I do. Officer Carson Payne, Kentucky Department of Corrections, Probation and Parole.
Mr. Payne, have you been supervising Mr. Smith?
I have been supervising him since he completed drug court.
And my understanding was he completed drug court, I'm trying to think, about 1.5 years, 2 years ago. Is that correct? When did you get supervision?
He completed drug court June the 10th, 2024.
So it's 2 years ago.
Yes, sir.
And since that time, have you had any community complaints or any issues with Mr. Smith?
I have received numerous community complaints that he has been using alcohol. I have followed up on all of those complaints. And most of them, by the time I have tested him, it has been out of his system. Since he completed drug court, I have had 2 previous uses of alcohol, and both of them was admissions. And then this one on June the 8th was an admission also.
And how long did he admit to using alcohol during this admission?
On June the 8th, client verbally admitted and signed an admission sanction form to the use of alcohol on or about June the 5th and June the 6th. Also admitted that he had been drinking alcohol on Fridays and Saturdays for the past month.
And based on that month, and then you've got 2 previous admissions, this has been an ongoing problem, hasn't it?
Yes, it has.
Okay. Nothing further, Your Honor.
No questions for Mr. Payne.
You said community complaints. Was he out causing problems without disclosing it?
Most of them was just anonymous calls that I received that he had been drinking.
Did they say he'd been I know it was not supposed to be drinking, but they say he'd been causing any problems or misbehaving.
There was also the Kentucky State Police thought they turned on him once and he got away. They have no proof of that. They thought it was his truck, but they are not sure. That was one complaint I received also.
And then you also had the problem, he was charged in Tennessee. I think, Mr. Payne, if you stay on, he had a charge in Tennessee, is that correct?
Yes,
Are you aware of that?
yes, his charge in Tennessee was on July the 15th. He was of 2024, Detective Levi Thurman attempted a traffic stop on Highway 11, intersection of Wolf Creek River Road for swerving between the lines. The truck was a silver single cab Chevy F-1500. It says the tag number and it would come back to Hugh Smith, Adam Clay Smith's father. Detective Thompson pulled up beside the vehicle and saw subject Clay Smith driving recklessly. The subject had been driving at a high rate of speed at approximately 90 miles an hour. We passed four vehicles putting their lives and my life in danger. The subject turned onto Highway 127, then into Kentucky, where they advised Clinton County. For the reasons I above, Detective Levi Thompson charged Adam Clay Smith with 5 counts of reckless endangerment, failure to due care, evading arrest, and improper passing and reckless driving.
Yeah, now what was the disposition of that case, if you know?
That he was given a suspended sentence and it was dismissed after 6 months.
Okay. So this is a problem we've got, Your Honor. It's not just the drinking recently. This has been an ongoing problem since he graduated
I
drug court.
absolutely don't understand those sort of charges, how you could do that. So do you want to call any witness? You want to inquire of this witness?
No, Judge.
Do you have any witnesses you'd like to put on?
I don't know whether Clay, I don't think, Clay, would you like to testify?
About,
What, I didn't hear what he said.
He said about what?
Yeah.
Well, I think he agrees largely with the factual contents of Mr. Payne's testimony. And I can kind of state his intentions for him in an argument for.
Go ahead.
In lieu of revocation. Judge, I mean, that's 2 years clear of that incident in Tennessee. And like the court has noted, not that drinking is allowed in the situation. It's not. Drinking can lead to just as many bad things as substance use can. But Mr. Smith sounds like he was pretty, every time that they've caught him, he's admitted to it. So he's been cooperative.
How about the times they didn't catch him? That's what bothers me. You know, I mean, he's driving like a madman at 90 miles an hour up through here while he's on probation. This court, I understand your obligation to defend him. But one of my worst fears, since I've been on the bench since over a decade, is to have somebody out like this and they run over a school bus or some innocent person and kill them over there because we didn't do our duty, or the people down in Tennessee let him off. So, you know, I'm not, and he didn't want to testify today, evidently, about what? Well, about what is his not willing to live a normal, compliant life and to not subject the public to danger of driving under the influence.
Judge, I would know he was not charged with driving under the influence in Tennessee.
No, but he's drinking all this. He's drinking and he's.
Well, there's no allegation of driving under the influence.
Okay, I withdraw that. He's not drinking and driving 90-something miles an hour. I'd understand if he was drinking, driving 90-something hours trying to evade. If he was drinking, and if he's just doing it out of poor judgment, but his conduct to me seems to indicate that he's not willing to be compliant. And how much time does he have on the show?
It's a 3-year sentence on possession, Your Honor. I don't know how much time he's got in. I don't think he's had much jail time before, except this last time.
He'd be eligible for shock probation.
He would be, and I know he completed drug court. My understanding is he went through pretty much without a hiccup.
That's a double-edged sword to me. If somebody completes drug court, they give you all this tools, the state invests all this time and money in him, and then you go back to your prior conduct. But that, to me, but I'm not the judge. He's going to be eligible for shock. If he wants to do long-term treatment for his alcohol abuse, that's something I'll look at.
I'm going to revoke him and you do a shock probation motion for him. And between now and then, you can consider whether he's willing to give up alcohol, in exchange for his freedom.
Well, he'll have to be sentenced next month. on
Yeah.
that.
Yeah. Okay. Schedule a Senate to order a, it was a pretrial diversion or revocation or a pre-sentence investigation report to be sentenced on, July 23rd. Okay, thank you very much. Jacob Voorhees.
Judge, may I be excused, sir?
Absolutely.
Thank you.
Cromwell versus Jacob Voorhees. Are you Jacob Voorhees?
Sir.
Good morning. Were you born in 1991?
Yes, sir.
Last four digits, social security number 5782.
Yes, sir.
Okay, you're here on 16 CR 0077, 17 CR 0029, and 20 CR 0005, shock probation revocation. Mr. Cross was a comment.
Your Honor, he also was on, probation for, I think it's a 3-year sentence. I didn't write it down on possession. He's going to the grand jury today on a new possession case and tampering with physical evidence where he allegedly swallowed meth during the traffic stop.
You want to schedule it for the 13th?
Yeah, we'll see if we can wrap it up all at once.
23rd for the next appearance. Maybe you can wrap it all up in one thing, Mr. Voorhees, okay?
I'll be talking to you.
Thank you very much. Carol Walker for sentencing. Commonwealth versus Carol Walker. Are you Carol Walker?
Yes.
Good morning. You're here on 25 CR 0085 and 26 CR 0017. Ms. Walker, were you born in 1991?
No.
Oh, excuse me, 1965. Excuse me.
Yes.
Wrong page there. Last four digits of social security number 9875.
Yes.
Have you had an opportunity to look at the pre-sentence investigation report number, probation and parole?
Yes.
Substantially correct.
Yes.
Is there any reason why this lady should not be sentenced today, Counselor?
No, Judge.
Or plead guilty to burglary second degree in 25 CR 0085, the defendant shall receive a sentence of 6 years for pleading guilty to burglary second degree in 26 CR 0017, she will receive it 6 years. These two sentences shall run consecutively for 12 years, serve 8 months, probation 5 years, probation be served, supervised. To enroll in long-term rehab, she shall pay restitution of $4,600 from release Boston and the rate of $200 per month. Once she's released from jail, she can do 30 days from release of incarceration. What's the court cost?
Both cases together will be $170.
Yeah, I'm gonna merge the court costs. So it'll be what? 200 what? Okay, so in addition to $200 per month, she would pay $30 toward the court costs. Sorry, 30 days. How much time does she have in now?
Roughly about 6 months according to PSI.
It's got a couple more months.
It's the follow-up attorney and the attorney, the burglary first, what's in the plea.
Yeah, they need to initial, y'all need to initial the change to second degree burglary. Ms. Gordon Anderson, can you come up and initial this for the Commonwealth? Byron Weber. Byron Weber. Twenty-six CR 0023. Are you Byron Weber?
Yes, sir.
This is, were you born in 1961?
Yes, sir.
Last four digits, social security number 7523.
Yes, sir.
Okay, you're here for sentencing today. Have you had an opportunity to look at the pre-sentence investigation report number, probation and parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
Is there any reason why Mr. Weber should not be sentenced today?
No, Your Honor.
Upon plea of guilty, wanting in danger of first degree in possession of firearm by a convicted felon, he shall receive a sentence of 1.5 years on each charge to run concurrently for 1.5 years. What's the court cost involved?
$220.
$220 payable $30 a month so it's paid in full, begin 30 days after his release. Should be forfeiture of all the evidence they made. Okay,
Yes, sir.
thank you very much.
Thank you.
Is there anybody else up there at the Dyer County Jail that we hadn't addressed?
No, sir. That's everybody we
Okay.
have in custody here.
Thank you very much. Y'all are released today. That concludes the criminal session of the Cumberland Circuit Court. Let's go off the record.
Yes.
It's shocking. Will you and counsel come up here for a little? Yes, shut that off. Okay. Guess I get to go.
It's a lot, it's a lot over.
Oh,
Did you have it
no, I can shoot that. Yeah.
That's your call. I'm trying to get them to go inside the church. They've asked about changing it to the dollars. They were showing that.
If your case is not before the court now, turn your cameras off if you will. So, thank you very much. Is the Riddle case the first case on the docket? Riddle versus Collins and Rhodes. Your motion, Mr. Bertram.
Your Honor, yeah, that's our motion to modify custody based on the father's incarceration. Court interviewed the child in chamber that we reviewed.
You had an opportunity to review the interview.
I have not, Judge. As I explained when I sent the emails out, when Mr. Bertram asked about dates, I was out of town until late Tuesday night, so I've not had a chance to see it.
We're just merely asking for the 50-50.
I know, interesting. What's y'all's response to that?
Judge, obviously there are some concerns. One, thank you, just from.
Let's move over here and get you behind the podium. This is voice activated. And that one over there is not working too well. Go ahead.
I think there's concerns that this child doesn't have any friends in Tennessee, doesn't really have any support system other than Ms. Collins. I saw the affidavits that were attached, but they really don't provide that these people actually have a connection or relationship with the child. There's also the issue that we had to have addressed before this court back at the end of last year. The child has Kentucky Medicaid. That can impact the child's insurance. She lives in Tennessee and all of the child's providers are in Kentucky. So that's another concern if the court does a 50-50 timeshare. And I think that's what Mr. Bertram is asking.
Well, let's go back. I don't think he's asking necessarily for a 50-50 timeshare, but let's go back to the Medicaid. If you had a child that you shared visitation or time with across, I mean, one of them has to be designated as the primary residence of the child for insurance purposes.
Yes.
I don't think anybody would give up Kentucky Medicare for TennCare. I don't think so for a child. But I'm disappointed that you haven't had an opportunity to do the interview. I was very impressed. The child was very articulate, very smart, presented very well. Didn't want to hurt anybody's feelings. Very sensitive to that, everything. But he wants to spend half his time with his mama. He loves his grandma and he's very appreciative of what she's done and her husband done. But he was very adamant about it without being forceful. He said he likes the way things are now, and he made reference to where his father was and everything like that. So he understands the implications. So I've gone through a lot of things and I've watched a lot of trials and tribulations of the mother in this kind of case. It seems like quite a bit of progress has been made, stability there and everything. So I'd have to have, Ms. Thomas, who do you represent?
The child.
What do you have to say about it?
I've watched the video, and as you said, Waylon was very articulate.
Don't call his name.
I'm sorry. He was very articulate. You made several proposals, different options, alternatives. The biggest concern I have, he expressed to you that he has FaceTime with his dad. And if he spends a greater percentage of his time in Tennessee, will he have and be afforded the time with his father's family, his younger sibling? those are my concerns, as well as being able to keep up his contact with his dad.
Do you have anything else you have to say?
I was gonna actually address that as well, Judge, and then I think there's an issue that a lot of the Fridays and looking quickly at attendance records, it looks like the Fridays that Ms. Collins has the child, she doesn't get him to school, so there's concerns and worries about that. I mean, in particular, the last day of school, she didn't send him to school, told my client that the child was sick, and then the child indicated that he didn't know why he didn't go to school that day. So again, I still think there are concerns. I've seen messages between the parties and there's co-parenting issues. So I do think that doing a straight equal timeshare would have a major
What is
impact.
your client asking for now?
Just what the child's requested.
No, I'm not,
She wants an equal division of time. She said the week-to-week schedules works fine, always has. He said.
what about getting the child up here on time for school and on Fridays and things like that?
You can pull the school records. I have him up here on time. And if he's sick, it's because he's sick when he's come from her house, with the doctor's excuse. He has no unexcused absences.
Okay, let's say we do a judgment on this thing, a modification. Miss Hayes, tell me 2 or 3 things that you'd like to see in it besides just straight 50-50. One of the things would be that what Miss Thomas Anderson talked about would be some certainty of continued contact with the father through Zoom or something like it. You have no problem with that?
I don't, his father chooses not to call when he's in my house. It's not me.
Okay.
And Judge, he has a half sibling that time with that child would be very limited, as well as his time with his grandfather, because I think right now the child has a pretty likable interest in horses. He wants to be involved. That's where he's doing FFA.
I think
and
this
things.
child, from what I see, is gonna be able to advocate where he wants to go. Myself, I don't think, I mean, he has I think if you want, go ahead and tell your attorney.
His time with his grandfather will not be bothered by my time.
Yeah,
And I support all that Byron does.
yeah. Okay. Okay. Okay, is there any other concern? Now, there is also the situation, I don't know the time period that the father is going to be incarcerated. I have no idea what that is because I wasn't on that case. You know what that is?
Judge, I believe he's got something coming up, a
Yes.
hearing coming up pretty soon in the next couple of weeks that could change this circumstance.
Yeah, okay. You know anything about that?
No, Judge.
I mean, reduce it or something like that. I don't want to go into that here, but I will say that at some juncture, if he comes out and reestablishes himself in the community, we probably have to revisit the thing again, because I absolutely don't see the situation where Miss Rose will lose her status that she has. She'll keep her status as a de facto custodial person with equal rights as the other 2 parents when it comes time to, if that ever comes out there. But, the concerns over Miss Collins, her conduct, some of the things in the past was the reason I ended up doing a 2/3 third. And although we haven't had extensive testimony concerning that right now, it appears to me that it's time to try the 50-50 with an understanding that you need to live at the foot of the cross. You understand? You need to live at the foot of the cross. You need to be very careful because you have people that are suspect of whether or not you can conduct yourself the way you appear to be conducting, and your son is very observant and intelligent. And so I think I think he's old enough to take care of himself now and watch what you get. He loves his mother and he loves his grandmother. So, you tell you got something else you'd like to be included in it?
Well, I haven't spoken yet, but.
Well, I'm giving you an opportunity to.
Okay. Yes, one of the things that concerns me, Judge, is this is his summer vacation. And she has a job and no one to care for Waylon. So when she's at work, he's home by himself.
No, he's not.
Wait, don't say anything.
When he's here, he has several friends that he's with all the time. Then he has to go ride his horse. That's his big thing right now. And he has to go help Pa Riddle. They're in the hay. And he's a big help to them. I think that it would be doing Wayland a disservice to not allow that on his summer
But
vacation.
Wayland doesn't feel that way about it. So, you know, and when Wayland wants to go see his grandfather, ride his horse, if she doesn't make that available to him, then she'll pay the price of the relationship coming back, and y'all can come back to me at that juncture. I'm not saying your concerns aren't justified. I'm just saying if that becomes a problem, I'm here. I'm here and available. Do you have anything else you would like to include in it?
That's all you're.
Do you have anything
The
else?
only thing I would say, Your Honor, is alternate the tax dependency deduction each year. It would be very helpful to her.
Judge, I would like to leave that the same. My client has been bearing the financial burden for this child. Neither of the parents paid child support.
I'm gonna hold off on that. How old is he?
15.
15. Let's wait a year or so when things start getting really expensive, and we'll see who provides and what she starts providing and how adequate what she's providing, since she hadn't provided all these years. And we'll revisit that in the future. I'm not going to change that right now.
The only concern I have with a straight 50-50 judge is, again, back to the Medicaid. I think it's going to cause a complication if we don't have a 60-40 split.
How about 51-49? If you
So
know, I
long
mean,
as-
what's the significance of 60-40? And you give me some data on, or some law on saying if you got a child that's partially out of state and in state, you know, then we'll take a look at it. But nobody wants to get the Medicaid, the K-chip situation changed, so.
That's why I want to make sure that
Well,
that is still.
make sure that we'll, you know, if you think 51-49 or whatever it takes, but I'll give y'all some time to take a look at that one issue there as far as the insurance, because we don't want to get the coverage down. So, after the history that we have in this thing, I have some reservation about this. But hope springs eternal, and children love their mamas. And they need to have a good relationship with their mother. And I hope this works out. But if this doesn't work out, you know, if we have to come back here again and there's some kind of problems, don't come back thinking you're going to get even a third. Okay? Okay, thank y'all very much.
Judge, there's one other thing. I just want to make sure I talked to Mr. Bertram about this the child has an event July the 24th overnight for the expo at WKU. And then he's going to be at the Kentucky State Fair. I'm putting the dates August the 19th through the 21st that he has overnights, both for his FFA program. I want to make sure on the record that it's going to be ensured that this child gets to those events.
No problem.
Okay, well, let's put it in order. Okay,
You want me to draft the order, Your Honor?
yeah, draft it pretty quickly and get it over and we'll get it signed. Okay, thank y'all very much. Okay. Justin Allen Wright versus Kendra Leanne. Now we have 3 cases.
I think that takes 3 cases off your docket, and
Yeah.
we actually are scheduled for 2:00, another case. And council have discussed this, and I'm hoping we can do all cases involving these parties at the same time.
What time is it scheduled for?
The other one is a confidential case, and it's scheduled for 2:00.
There's 2 cases at 2, but they involve all the same matters.
Well, the new jury's coming in at 2.
And we're basically just needing a date so that we can consolidate all
You agree
5
with that?
cases.
Yes, Your Honor.
Well, let's do
Council
it
have
now.
discussed this, and we're looking at, my client has an assessment scheduled at the end of August. Ms. Thomas will not be released until, for a multi-hour hearing, until.
After July the 21st is the next surgical eval.
So we were looking at
I don't want to get into the
possibly
medical situation.
possibly getting something scheduled, did we say?
Mid-October.
Mid-October.
If that would work with the court schedule.
Yeah, I'm sure there's something available mid-October.
We really didn't discuss how much time we needed, but I would think, Your Honor, maybe half a day.
I'd say,
At least, yeah.
I'd say it won't go beyond a half a day.
Yes, sir.
Okay.
Certain amount of certainty. Look at October. The 7th.
I'm sorry, what date?
7th, it's a Wednesday.
That's fine, Your Honor.
Could we go down 14th or the 28th?
We could go next December. I mean, you know,
I'm not being facetious, honestly.
Well, I'm not either, you know, I mean, the 14th would be okay.
14th is
all right
fine.
with you?
At what time, Your Honor?
9,
Central, correct?
that's where we live.
Okay, and we had agreed that we're gonna exchange witness lists 30 days in advance.
That'd be good.
Do you wish for me to prepare an order for the hearing or?
Well, it'd be good if we had some kind of order that said what the issues that we're gonna be addressing.
And I believe all councils agreed and our clients to consolidate all 5 cases.
We have, Your Honor.
So that might help streamline the court's calendar.
Council will work together, Your Honor, to come up with an order that discusses what the issues are.
Okay. You serve that, let's say 30 days beforehand, okay?
Okay.
October 14th at 9 a.m. then.
Yes.
Okay, thank y'all very much.
Thank you, Your Honor.
Thank you, Your Honor.
Your Honor, I don't have anything further
Yeah.
before the court may.
Have a blessed day.
Thank you.
Excuse Your Honor.
Yeah, have a blessed day. Westbin Mutual Insurance versus Fletcher.
Your Honor, I'm Gene Zipperly out here for the Westbin Mutual Insurance Company.
Welcome.
Thank you.
Robert Deweese appearing via Zoom, Your Honor, for the defendants. I recently entered my appearance.
Yeah. You have a renewed motion for summary judgment, is that correct?
Yes, sure.
Counsel, you welcome to this case that's been going on for a long time. We've given your clients every opportunity to have counsel. They've gone through counsel. They went through a period where they were representing themselves, that sort of thing. I assume that you have reviewed this case up to this juncture, and it appears to me that it gets down to the point of whether or not the only possible defense that there could be is whether Westbin paid out to a vendor who wasn't entitled to file a lien on the property, and whether that would relieve them or not. I can't think of anything else, but have you seen any legitimate defense you have to any of these things that have been brought up by Westbin?
To my knowledge, right now, Your Honor, that is my client's position. And I don't disagree with the court that is its defense at this point.
Well, and I have given them every opportunity to show me some law where the obligation of the bond company is only to make a payment to protect the property from having a lien filed against it. And I haven't, it appears to me that there is a larger obligation out there for the bond company than just to prevent materialmen's or mechanics liens from being filed. I mean, it doesn't limit that. The policy or the bond doesn't limit that. Do you have any case law that says that would give them any defense? Counsel, I'll let you address that issue.
Your Honor, there's really, the bond is a payment bond, as you well know.
That's right.
And so there's really no defense with respect to whether a lien was filed or not. Our obligation under the bond is to pay the obligee your consolidated pipe because the Fletchers didn't pay consolidated pipe. As you well know, Your Honor, through the many pleadings that have been filed in the arguments before this court, every opportunity was given to them to, either pay the bond or not. We withheld payment for months from Consolidated Pipe, requested information from them.
And then they agreed they owed it and we're gonna make payments of $1,500 a
And
month.
as Your Honor, put your finger right on it, they already paid us $12,000 back, so it's hard to realize how you go back now and say you never owed the money in the first place, so.
Well, do you have anything, counsel, as just interference, you have anything that you'd like to preserve for the record as far as if you appeal my decision here? Do you have any statement you'd like to make?
Other than my clients did ultimately, they hired me just recently, early this week, I think is when I filed my appearance. I would ask leave of the court to roll this to the next motion day next month to allow me to file a response and I can appear in person.
I usually would do that, but we've rolled this thing for years. I mean, they've gone through at least 2 other attorneys and they made a period where they filed all the attorneys. And I'll give you an opportunity if you want to have, I'm going to issue a summary judgment in the case and I'm going to hold off making a decision on attorney's fees and other things that might be presented at a later date. And I will allow you to file a motion to reconsider. I'm not going to delay this any longer. I'll go ahead and do it. And you can file a motion to set my judgment aside or amend or vacate the thing. I'm just not willing to get a bunch of other things filed and extend this out for another 1.5 years. Okay.
Understood, Your Honor. Thank you.
With respect. Okay. So will you submit a judgment, a proposed
Yes, Your Honor, we
judgment?
will. And if I understand the court correctly, Your Honor, you want us to submit a judgment with respect to the liability portion and the principal damages and hold off for a further hearing with the court with respect to the issue of attorney's fees and costs.
That's correct.
And Your Honor, if I may, with the court's permission, the plaintiffs, when they were pro se, filed some sort of a pleading. It wasn't responsive to the motion for summary judgment, but it is a motion. And we've gone through it and there are cases cited there that don't exist, statutes that don't apply. I don't really want to respond to it, Your Honor. I don't.
Okay, well, I'll strike the pleading.
Thank
Know what you want me to do? Strike
Yes,
the
Your Honor,
pleading?
that was what I was going to request.
Might be an AI generated thing.
It could be, Your Honor.
Okay,
All right, thank you, Your Honor.
okay, thank you very much. Counsel, welcome to the case.
Thank you very much, Your Honor. That's all I have.
Okay, thank
Your
you.
Honor, I have no further business. with the
Okay,
court.
have a safe trip home.
Thank you.
Kohler versus Kohler.
Alan Dodd, Your Honor, by Zoom for the petitioner Charles Kohler.
Yeah.
I represent Debbie Kohler, Your Honor. She's on.
Wait just a second. We'll get some hearing assistance things on it. Okay, Kohler versus Kohler.
All right, we recently entered into 2 agreed orders. I think Mr. Dodd has filed those by e-filing earlier this morning. I have 2 copies here. They're signed by both parties.
Yeah, one of them has to do with one of the accounts that was premarital property, correct? What was the name of the account? That was
Vanguard.
Vanguard, and you agreed that that was an unmarital
Yes.
property, okay. And what's the other agreed order?
The other one contained 1, 2, 3, 4, 5, 6 paragraphs, and those are all stipulations that we
Agreed to.
agreed to. Yeah.
Okay, now have you reduced and we'll accept those as agreed orders. Mr. Bailey,
Judge, if I may interrupt, I'm sorry. The second one, we've exchanged emails. We're trying to resolve some differences on the second agreed order. The one regarding the Vanguard account, we did sign. Mr. Bertram e-filed it this morning. That's
okay,
correct.
well, I'll sign the Vanguard and you hand him the other one back because it's not an agreed order, it's agreed to, so.
Well, Mr. Dodd, what there's nothing in that you took out paragraph 4 in that order. So, and
Okay,
I stopped
so,
that.
right, if you remove the paragraph 4, we've just exchanged several copies today. So if it's just removing that paragraph 4, then I'm fine with it.
That's what it is.
Okay. Yes, sir. Then that's fine. I just can't see what you're handing.
Well, if you were here, you could see it.
And
No, and this
I
is.
offered to come down there, Your Honor.
To me, this is a kind of case that's hard to practice on Zoom because these parties can't agree on anything. So I want you, next time this case is here, I want you or somebody on your behalf to be here. You understand what I'm saying?
Crystal clear, Your Honor.
Okay, thank you very much.
Paragraph 4 is, and I have it right here, what we proposed, but it pertains to the court's ruling at the last hearing. It said, well, when the parties sold Arden Lane, they agreed at that time to divide the proceeds 50-50. And if the parties so that constitutes their separate property, if they're able to trace it into a current asset, that's going to remain their.
What was the name of that property again?
Arden Lane.
Hardin Lane.
Arden. Hardin Lane.
Harding Lane.
Arden. Arden.
Okay.
Maybe
it's a Hardin for me. Okay, go ahead.
Anyway, we've exchanged a paragraph, and the way I've done it now is to rephrase it. Mr. Dodd can chime in, but it says the parties agreed to equally divide the proceeds from the sale of Arden Lane, and they each received a check for $349,698.12. They separated at that time and lived apart, and after a brief trial period of cohabitation, separated again. The court will not question the fairness of the parties' agreement to divide those proceeds 50-50 between them, to the extent to which the parties can trace their respective Arden Lane proceeds into specific assets now in existence. They are entitled to claim a non-marital interest of up to $349,698.12 each. Put a comma, subject only to husband's ability to trace his non-marital interest in Foxfire. And I think at the last hearing, you said you were going to give him that opportunity to try to do that. If he doesn't produce much, there could be an award of fees.
So, Judge, rather than negotiate this paragraph on the record, I think counsel and I can work it out, and I still need to talk to my client about counsel's proposed language change, which I haven't had an opportunity yet.
That sounds reasonable. That sounds reasonable. He proposed this language. He'll send you that language, and then you'll, after consultation with your respective clients, see if that's agreeable. And we do agreed order. Now, let's say hope springs eternal that there'll be an agreed order on that. What issues are left to be resolved if you have an agreed order on that?
We have other tracing issues. You'll have his allegations that he can trace Foxfire. We have some non-marital tracing claims of our own. And
okay, well, what I want and what I thought I did last time, and I will admit that I vacillated back and forth a little bit last time when I was hearing various arguments, so I can understand how there might be some. I want a distinct list of the issues that we're going to try, and then we're going to try them. Okay, I want to see what there is to be decided from both sides' perspectives, and then I'll try the case. We'll take the evidence, and as my old law professor used to say, we'll let them lay where Jesus flings them. Okay, so I'm ready to get to that point. I'm tired. Y'all are tired of this case. We need to get that. Now, counsel, do you think that you can participate in setting the issues that I need to decide? And if there's anything you can't agree on, that, it's an undecided issue that I'll have to be decided. So you don't have to agree on those issues. You'll just have to give the issues that you want me to render an opinion on. How long do you think it'll take you guys to do that?
I can submit a list of issues easily within a week, if not sooner, if Your Honor would like it.
Okay, well, why don't you submit them to each other?
Yeah.
And see if you can, if you have some of the same issues, it'll get a bunch of the decision points down to a lower number of decision points. And then I can give you a trial within 60 days of that. It doesn't take very long and that'll give you an opportunity to schedule witnesses and that sort of thing. And we'll get this thing out of the way. Okay.
Your Honor, I can just tell the court from our position, because there's agreement on Mr. Kohler's other two non-marital claims, other than maybe some personal property. His remaining non-marital claim is regarding the Foxfire house. I know that Ms. Kohler has some non-marital claims that,
I can't hardly hear you. You've lost me somewhere. What are we talking about now?
Yes, sir. I mean, it's mainly now the division of marital property. We have a claim from the original Foxfire house, but we'll put a list together.
Yeah, well, that's what I'm saying. You put a list of decision points that you want me to make a decision on, and anything that you can't agree that's on there, put it on there anyway, and I'll make a decision on it if you can't agree. And if we can get it down to 10 or 12 points when we try the case, we can hear the testimony, but I have a tendency to move from decision point to decision point if they're not related. In other words, any testimony on a particular piece of property, I want to hear that separately. So we'll create a record when it goes up, which inevitably will, so that there can be findings that we make on each one of these decisions. Does that make sense?
Yes, sir.
Okay, well, thank y'all very much, and I would suggest maybe within 15 days, y'all send me a joint statement on that thing, and then you don't have to come back. We'll get our calendars and set a date. You always start looking, and I'll have my calendars, and I'm not gonna have my staff lawyer call you back and forth and back to try to get a date. I want both of you on there. We'll come out here and get you on the record by Zoom if necessary to get a date, okay?
Thank you.
Okay,
Thank y'all very much.
Thank you.
Absolutely. Parrish versus
Exchange location.
Shawhand.
My client's in Saturday in one of the bands, Grand Ones.
They're just about changing on Sunday. Did you talk to her on that? She's not in agreement if we don't do the exchange.
Should probably be in agreement. It's just an hour. I'll advise her to do that, but
I don't.
we would gotta work something out on the exchange.
This is silly.
I got this for ready for court.
Hello.
Okay, what do we got going on here?
You set this for a motion for review after we had previously filed a motion to modify timeshare based on Mr. Parrish's
Well, it's a
criminal
court
charge.
of opinion.
It has not been entered yet. It is still in chambers is the status they gave.
We're still waiting an opinion from the Court of Appeals.
So I guess we'll just continue this generally until we get that opinion.
Could we go ahead and set for a review next month?
You can set it whenever you want to,
Okay.
I can set it next month or whenever, but until we get the opinion.
Okay.
Judge, and I think one of the only.
You can set it for next month and just by agreement, y'all just won't appear. So these parties won't have to appear if the opinion hadn't come in, okay?
That will be fine, but Judge, I think we may need to change the pickup location. I don't think the pickup location is working very well right now. And we would like some suggestions from the court. Opposing side has suggested dispatch at Cumberland County. However, there's no good audio or video recording up there. And given
Is there
that
problems with the pickup now?
there's always problems, Judge.
There hasn't been any issues at pickup for quite a long time. It's just a very extensive drive for my client. They're currently doing exchange at the Kentucky State Police in Columbia,
Where does your client live?
Burkesville.
And where's your client live?
Breeding, Judge.
Well, you pass through breeding to get to Columbia, so
If you.
he'd rather have somewhere here in town than Columbia.
Okay. Apparently, Ms. Shawhan does not want to come to the Purdue residence.
I can't hear you.
Ms. Shawhan does not want to go to the Purdue residence. to
Well,
pick
I'm
up the
talking about,
child.
is there a public place here?
Do you have any other suggestions?
We suggested either the Dollar General approximately close to Miss Purdue's home. They've met there in the past with no issue, or a gas station. near the
Well, there are a
Purdue
lot
home.
of, there's a Dollar General on every corner. That
Yeah,
doesn't-
I'm not familiar with Burkesville. We have a better street address for that.
It's the one in Breeding. They're familiar. It's right next to their house.
I know where it is. Let's try the Dollar General up there. I don't want any problems. Okay?
Yes, Judge.
I don't know about everybody be like peaceful, okay?
And I guess try their best to be in front of any surveillance cameras they may be seeing.
I'm sure Dollar General's got them everywhere.
Yes. Yes.
Okay. Okay, thank you very much.
Thank you.
Yeah. Epling versus Anders.
I'm sorry, Judge. Apparently there was a remaining issue. They need these days to be on Sunday, due to church, from 1 to 7 is the only change that they're requesting.
And we were agreeable to
Okay,
switch from
just
12 to 6 to 1 to
agree
7.
over.
We just wanted that noted on the record.
Okay, thank you.
Thank you.
Epling versus Anders.
Confirmed they're still going to let Fayette County kids good birthday party this Saturday.
What?
You want to be moved, Judge?
Well, move.
I mean,
Yeah, just share the podium here back and forth. When you speak, you can either move to the right. When she speaks, she'll move to the left. My left, okay? This is a motion to alter, amend, or vacate. You, Mr. Epling, you may be heard.
I had a few housekeeping points I want to clear up first of all, and then, and then another talk about the summary judgment. No more than 3 minutes. If you give me a leeway. I had a medical event last summer, somewhere in my head, and it jarred something loose in a existing. So I think it probably qualifies for the ADA Disability Act, and so I really appreciate all of your help to me to pay attention. So I'm getting better, so I can speak a few words here today. Next of all, I need to explain, last time I heard some disparate things about me that I took to see that were going into your decision. So I need to clear up some things.
I don't know what you're talking about.
Well, I'm 72 years old, and
well, I'm 73.
I know that.
Yeah.
You're close. We've
okay, well, go ahead.
So
we've established that. This is a motion to alter or amend or vacate. So
this is on the record, and I'd like to clear this up to make sure that it gets on the record. I'm 72. This house that you're getting ready to give away and make me homeless is the only thing I have. I don't have anywhere else to go. I don't have any guns and lawyers coming in to rescue me. So there's that. Now, talking about this summary judgment, the issue is off the tracks. If you look at my complaint, there's nothing in there that says anything about as is or whole house inspections. The core issue here is multiple statutory law violations, and the law violations don't go away when they have a contract. And I am an innocent person. I haven't done anything wrong, and I'm an innocent person and a victim of statute law violations. This is the only outlet to address that. There's no police or squad that's gonna come in and take care of that. I'm trying to help myself with a simple thing. So you can't accidentally wire a residence. Someone had to do it, and it took a lot of actual knowledge to do it. And in this case, it would have been okay to say yes on the disclosure form. That would have been an honest answer. Honesty is always the best policy, but this would have indicated, yes, there's something wrong with the electrical system. Namely, there were a bunch of legally required electrical permits missing. The defendant claims that his best knowledge and belief do not include anything about the electrical installed on his watch. I have evidence in the file to the contrary. So there is a controversy. This poses a significant questions that cast this summary judgment into question. Lastly, I'm here to move the motion before the court to vacate the summary judgment that was granted on June 27th for the reasons set forth within and elsewhere noted. I'm through, Judge.
Thank you so much. Would you like to come over here and respond?
I can respond from.
I'd rather you come over
Okay.
here. It's not activating the camera for some reason today. Thank you. You can move to your left a little bit, sir. Move to your left a bit. Okay, go ahead.
Judge, the summary judgment is valid. There was no genuine issue of material fact in dispute here. He had a contract. He signed off waiving any right to inspection of the property prior to the purchase of the property. The property was listed with Southern Nest Realty. He had the opportunity to work with a realtor. He chose to issue an agreed order releasing the realtor and the firm, that firm from any sort of liability with this property. And again, waived any issue with the personal owner through the contract by waiving the right to inspection, the right to look at the property, send in a professional to look at these issues. He completely waived that right. And now he has a case of buyer's remorse and he's mad and he's bringing it back to court.
Address me now. I'll call on you when it's your time. Okay. Now, what about the as-is claim?
Judge, this is pursuant to the contract, which was with Southern Nest Realty, where it gives the purchaser the right to have an independent inspection done for any defects with the property, electrical, plumbing, structural, whatever. Mr. Epling chose to waive his right to pursue those avenues. By waiving his contractual right, he has no claim.
Yeah, you finished?
Yes.
Why?
You move over this way and you get behind the party.
Why would I need electrical inspection when the inspection was done supposedly by law when they put the electricity in? They bypassed that, thinking that no one will ever see it. So we're not going to pay for any permits. So we're not going to have an inspection. We're just going to put it in however we can get it in.
Let me ask you something. Why didn't you go onto the property and have it inspected and have the plumbing and electricity? Why did you waive that?
I went on a walkthrough and the defendant was with us, never said a word about all this pirated wiring in between the walls, and he had a duty.
Well, I mean, here's the thing about it is, why didn't you have it inspected before you bought it?
I was in a hurry.
Therein lies your problem.
Well, I looked at the disclosure form and it said
wait just a second.
He lied.
Wait just a second. I do believe that you're an innocent person as far as not intentionally doing anything, but you do have certain obligations yourself when you enter into a contract. And why did you release the real estate company that had it? Why did you release them?
The real estate, the disclosure form was lied. He didn't put the electrics in, and then he wants to turn around and say, oh, there's nothing wrong with this. So he lied.
I don't think he's ever said there was anything wrong with it. He said he didn't know what there was.
Well, he's been talking to several people.
It's not, what you got, what I had to decide was what was in the evidence. Okay?
Well, what is in the
Wait,
evidence?
don't interrupt me. Okay? I'll give you an opportunity to speak. I'm not gonna alter him and to vacate this judgment because you have every opportunity to present evidence that you didn't, that you are entitled. It was no issue there. You waived the right to inspect this property and it is what it is. Now, you've done everything you can to preserve it. You can appeal it. If I'm wrong, I'll be glad to follow the Court of Appeals. Okay? So thank you very much. Okay, let's go to the next case.
Judge, can I be heard on my motion for attorney's?
I'm not going to grant any attorney's fees. Okay. Orchard Tax Lien Services LLC versus Michael Grover Gross.
Katie Lawrence on Zoom, judge for the plaintiff.
Okay, what do you have here?
Opposing counsel called and asked me to pass the motion for judgment. They intended to take care of that lien within the next 15 days or so.
So you want to pass over it?
Yes, please.
Okay, no problem. CML Tax Lien LLC versus USA Acting Food Farmers.
Katie Lawrence on Zoom for the plaintiff, and it's on for plaintiff's motion for judgment and order of sale.
Okay, I haven't had do you have an affidavit? What kind of attorney's fees are at 2,000 or below?
We included more than 2,000, but if you cap those at 2,000, judge, I can amend the order.
Cap it at 2,000 if you would, okay? What was the warning order attorney fee?
The total is included in our breakdown. Let me see, it is, I can pull it up just real quick.
How much is it? Where is it?
The total warning order fees I have is $1,058.61.
And what were your other, and you had litigation attorney's fees that capped at 2,000. What are the litigation costs? Break that down at 3,600.
So the 3,600, judge, and it's the line item breakdown is included as Exhibit C, but we have the filing costs, the certified mail, the sheriff's postage, the LexisNexis, which goes with the court filing, warning orders. We have the $200 master commissioner referral fee is included in that. The title abstract that we ordered was $152. Is that what you're asking me to?
I got it now. Okay.
Oh, okay, sorry.
You submit an order and limit the attorney's fees to 2,000, okay?
I will do that, Judge. Thank you.
Thank you very much. Dishron versus Dishron. Hey, what do we have going on here?
Judge, right now, we have a motion for contempt. Ms. Katz and I have spoke. I'm agreeing to hold this motion for contempt in abeyance We are expecting some criminal charges to come to Mr. Dishroom. He has not been served with those criminal charges at this time. We do have a mediation scheduled for Tuesday, and we are hopeful that we can at least resolve some of the potential property issues on Tuesday. We're already scheduled to be back here for the July rule day, and we can pick back up on contempt issues should Mr. Dishroom be issued with criminal charges.
Okay, that'll be fine. Scott versus Scott.
You want to say that for a few minutes?
Okay, what do we have here?
Judge, this is our
You
motion.
speak up a little bit if you will.
This is our motion for sole custody and suspended visitation against the mother, Marquia Scott. The father, Justin Scott, is asking for the sole care, custody, and control of the minor children. Ms. Scott was previously involved in a juvenile action in which she was not complying with the cabinet, was not passing any drug tests of that nature. She was not acting appropriate at the visits, and I think voluntarily terminated the visits until she was able to get herself in a better shape.
Is this Miss Scott? Is that you, Miss Scott? Okay. Where are you today, Miss Scott?
I am in rehab.
Okay, I don't want the location, but you're in a rehab somewhere, right?
Yeah, I'm Bowling Green.
What are you wanting from Miss Scott right now? I'm not going to permanently terminate anything. She's
No,
not
Judge.
here and she's not represented.
No, we're not asking for.
What are you asking for?
We're asking
Simply-
for a sole custody and suspended visitation until Ms. Scott can get out of rehab and we can see that she is on her feet.
Well, I will suspend visitation. I don't see a reason to do a sole custody. So give a temporary custody. We'll do a temporary custody and suspend visitation until she has an opportunity to get counsel and get somebody to represent her here. And how many children are involved?
4, Judge.
4 children. Well, we'll probably need a guardian ad litem appointed for the children at some juncture. Okay.
Okay.
So we'll do,
Judge,
when are you supposed to get out of rehab, young lady?
July 9th. The social worker was just here today and I talked to her and I had suspended my own visitations through DCBS myself until we got in therapy as a family. And she was actually going to put in a motion today for me to do video calls with my children while I was here, since I am applying.
He would like for those to be conducted through the cabinet. Any type of video call or that nature, so that.
Yeah, we can do that. See if the cabinet can get a hold of Miss Perrigan to put any kind of situation line up where you can talk to your children. Okay?
Yes, Judge.
Okay, and what we'll do is you also need to reach out to see if you could get an attorney provided for you.
Okay, I cannot do any phone calls or anything like that here at my stay in this rehab.
Yeah.
So it'll be after.
When you get a little farther advanced, you need to do that.
Yeah.
Okay?
Okay.
So there won't be anything done permanently. We'll just put a temporary with agreement you on that. And I want you to get out where you can lawyer up to make sure you can protect you. And then the next person up will be, I understand Mr. Poindexter is GAL in the, so I'll take your appointment on this case too, as a guardian ad litem in this case, if that's okay.
Yes, sir.
And he'll represent the children. And you also, one or the other of you might see how she can obtain counsel. I think she, yeah. So I don't know whether Mr. Carter's gonna be around. Okay, well, thank you for appearing, everybody. Thank y'all.
Thank you, Judge.
Yeah. Okay, Kerr versus Dyer.
Judge, we're here on a petition to establish de facto custodianship for Miss Michaela Kerr and Mr. Timothy Beatty. The minor child has been in their care for over 2 years. The child is now 4. She's been in their care since approximately turning 2 years of age. We have.
Where are the biological parents?
This is the biological mother. She's present here today, and she is agreeable with allowing Ms. Kerr and Mr. Beatty to take over the de facto custodianship.
Okay, where's the father?
The biological father was served in this action on 6/3, and he has not filed an answer or appeared today.
Who is the biological father?
His name is Jason Dyer, and he is involved in the juvenile action. And
Has he been involved in the child's life at all? Never has. Okay, well,
very rarely.
he's not incarcerated, he's not in the military. If you file an affidavit, he's not incarcerated in the military.
I can file one, Judge. We have an affidavit from the biological mother. But
Yeah,
we
you need to do an affidavit when it's military, he's not in the incarcerated, that, and then submit an order, okay? Thank you very much. Yeah. Second, finish the docket. Okay, confidential docket. Where is it? There it is.
It should be the last one.
This one, right? Okay, we have a confidential docket. Here's our folks here for that. Maddox.
Maddox, right?
Are the parties here?
Yes, Judge, there.
They are.
Somebody needs to get the parties here, Maddox, Newport.